Then ask counsel in 124946, Jeannine Williams-Davidson versus Dr. Louie and others to please come forward. Shepard, you may approach the lectern.
Good morning, and if it pleases the court. We are here because of a medical negligence case that was filed in Douglas County. We went through a couple of years of discovery. I filed on behalf of the defendants a motion for summary judgment, also a motion to dismiss, and plaintiff filed a partial motion for summary judgment. Judge McCabria in Douglas County granted our summary judgment, denied plaintiff's motions, and plaintiff appealed to the Court of Appeals. Court of Appeals reversed on the question of whether plaintiff needed an expert for the medical negligence claim she was asserting. I petitioned for review, you granted it, and so here we are.
Before you get too deep into your argument, would you agree then that the only issue before the court is whether the common knowledge doctrine applied to allow lay evidence on the issue of breach of the standard of care? In other words, res ipsa loquitur hasn't been preserved and causation is not before us.
I agree.
Okay, thank you.
There is also some issue about the KCPA claims.
Correct.
Okay. This case arises out of surgery done by Nason Louis at Stormont Vale for removal of a left adrenal, and he was assisted by another surgeon in his practice, Dr. Brian Boyd. There's some dispute about what time Dr. Boyd was present for the surgery. Dr. Louis, this is in his deposition, he prefers to have an assistant, and for the first part of the surgery, he had a surgical assistant during which he had to, it's called take down adhesions, scarring. Plaintiff had a lot of scarring. It took him about an hour. And then as planned, Dr. Brian Boyd came in as the surgical first assistant and helped manipulate the equipment that Dr. Louis was using for this procedure. It was a laparoscopic procedure. Dr. Louis inserted 2 trocars for taking down the adhesions. Then they inserted more trocars, and between the 2 of them, they manipulated the equipment, and through the camera at the end of the equipment that was inside, they could see what they were doing. I mean, that's how they saw the surgical field. The 2 of them eventually got to the adrenal gland, and as Dr. Louis has testified, the 2 of them acknowledged that this is the adrenal gland, and he removed it. Then they had the tissue that was removed sent to the pathologist, who initially thought it was an adrenal gland, but microscopic studies showed that it was actually part of the pancreas, which was a problem. And so Dr. Louis explained to the patient what had happened. A few days later, she went back in for a second surgery, which did remove the adrenal gland. The problem with the situation is plaintiff has argued that this type of procedure, where the intent is to remove an adrenal gland which had adenoma on it, benign lesion, the intent to remove that ended up with removing part of something else is subject to common knowledge evidence, or subject to the common knowledge exception. So she didn't need to have a medical expert, and she didn't. She didn't designate one. She didn't cross-designate one. She stood on common knowledge, and at that time, res ipsa. We, the defendants, designated Dr. Louis and Dr. Boyd as experts to testify that what happened sometimes happens even with the best of care, with reasonable care, and that's what happened. That is essentially their designation to testify that Dr. Louis and indeed Dr. Boyd complied with the standard of care by providing reasonable care, even though what was removed was not not the adrenal gland.
Why?
Go ahead.
I was just going to say that why isn't this just a wrong site surgery, and that falls into sort of the heart of the common knowledge doctrine exception in our case law and case law outside of our jurisdiction.
A wrong site?
Correct. I mean, typically when you remove the wrong organ, tissue, whatever, that's sort of been the stereotypical case where that common knowledge doctrine will apply to allow lay evidence of negligence.
The difference here, I think, is, and this is what we contend, that the adrenal, the pancreas, and another organ were so close together. It's not like you went here, but you should have been there. They were so close together, and the adrenal and the pancreas looked so much alike. And there was blood in the field. He'd been removing the adhesions so that between the two of them, they thought they were removing the adrenal.
So the complexity of this procedure made it something different.
Absolutely.
But is it true that the district court on summary judgment made only two findings of uncontroverted fact, one being that plaintiffs didn't secure an expert, and second, that there was no admission of a deviation from the standard of care?
That's true. Okay.
So the district court didn't get into complexity of the procedure or particular complications that the patient, this particular patient, may have presented.
It was presented to the district court. I cannot recall whether they actually went through why this was complex and what difference it made.
It certainly wasn't part of its uncontroverted facts that it found and set out. Okay.
And one of the significance of the uncontroverted fact that Dr. Louis admitted he made a mistake. A mistake is not medical negligence, but it gets argued that way by the plaintiff. Anyone else have a question? Is
there any evidence that providing the patient with informed consent, that the patient was told sometimes we miss the wrong organ and take out a good one?
The informed consent said that we don't guarantee any specific result. I don't think that it said we're going to go in and remove the adrenal, but we might get something else. I don't think it said that. It's an uncommon enough problem that it's not something that would be on the consent form, but it is a recognized complication of the laparoscopic adrenalectomy.
In looking at your motion for summary judgment, you have in your uncontroverted fact number 7, the statement that the adrenal, kidney, spleen, and pancreas are all in the same area and are very close to the pancreas. Beyond that, what do you have that tells us this was complicated?
Well, it's a laparoscopic surgery. It's not an open abdominal cavity surgery. And so the access is through ports that are inserted into the abdomen. The visualization is through a camera that's at the end of the port. And you're essentially working almost blind. You have to depend on the camera and your knowledge of the physiology there, which is what Dr. Louis and Dr. Boyd were doing. And that's why I say it's complex. It was not an open surgery. It wasn't like taking out an appendix, which of course can be complicated too. Answer your question?
Yes.
Okay.
So based on what you said, so if I have laparoscopic surgery to remove my gallbladder and they take out my pancreas, or part of my pancreas, because those two are close together. The fact that it's laparoscopic makes it complicated enough that the common knowledge wouldn't apply there.
I don't go that far, but the fact that this surgery was in an area where the pancreas and the adrenal were so close together and look so much alike, that made it much more difficult for the laparoscopic procedure. And they looked close enough, or what was removed looked enough like the adrenal, that two surgeons decided that was it, and that was what was removed. And that's uncontroverted. That's from Dr. Louis' testimony.
And one had an adenoma on it and the other one didn't.
Yes, it had a small adenoma.
That's uncontroverted?
That is uncontroverted. It's also uncontroverted that it was small, smaller than usual for surgery.
Counsel, if you could sort of back up for me and provide your understanding of the common knowledge exception. What exactly is it?
Well, it's along the lines of if for instance, a surgeon initiates a surgical procedure in which they are supposed to remove the appendix, and they remove some part of the upper or lower colon, and the appendix is still there. But all you're looking at, is the appendix. There's nothing else there that looks like it, or is the same size, or is the same color. So if you go in to remove, I say appendix, so my mother had appendicitis surgery a couple weeks ago. When you're doing that surgery, it is more likely to qualify for the common knowledge exception, because that was the purpose.
Well, I understand that, but I'm still trying to get a precise understanding of what the exception is, and I'll cut to the chase. Where I'm going with this is trying to understand the difference between the common knowledge exception and res ipsa.
Okay.
Because I think the discussion of these things oftentimes slides back and forth between the two, and I'm not certain that we've nailed down what we're really talking about when we talk about common knowledge exception.
Res ipsa is when you can see that the only way this result could have happened was if there was negligence. There doesn't have to be any evidence of negligence. It just is there, as with removing the wrong limb.
It stands in. Res ipsa is a stand-in. It stands in. It replaces the necessary evidentiary finding of a breach and causation.
Right.
So how does common knowledge operate differently?
Common knowledge, there has to be some testimony about what happened.
And then are we supposed to, in deciding whether or not to apply that exception, are we supposed to ask ourselves, would an ordinary juror know what an adrenal gland looks like, for example?
I think it's
I don't know that an ordinary juror would know what an appendix looks like. True.
Or even the location of any of it. I think you do have to ask that. And then you do have to consider that whether someone argues that a member of the jury could make that distinction. I have to go back to, but the two physicians didn't. It's not just Dr. Louis. And so that, I think, completely undercuts the common knowledge theory.
Is there any interplay then between this common knowledge doctrine and our evidentiary rule 6456 for evaluating the admissibility of lay evidence versus expert evidence? And if so, what is that?
I'm sorry, but I have wondered that too. The cases say, which can be, and lay evidence is allowed. And I'm not real sure what the lay evidence could be other than, I'm not sure. I've tried to find that in the cases and I couldn't.
Because it's not so much a lay opinion that you're looking at, it's just the lay facts from which you're then asking the question, does this doctrine apply to sort of infer a breach of the duty of care?
Yes, but it's not a flat presumption like a res ipsa would be. And speaking of presumption, we do have the presumption that a surgeon, a physician provides care within the standard of care. We don't presume negligence just because of the outcome. You know, my clock is not doing anything. I'm still on 10 minutes.
On 10 the entire time. I've watched kind of, and I think you're, yeah, I was gonna say, I think you're out of time.
Am I?
Yeah.
Okay.
I mean, at least as what you, subtracting the 5 minutes you
Okay,
reserved.
all right. Thank you.
So you still have that rebuttal time.
May it please the court. Justice Jason Belleville on behalf of Jeannine and Jeffrey Davidson. As we've now listened to, justices, we've now listened to a little over 10 minutes of oral argument, and I don't think the defendants told your honors what it was that the Court of Appeals got wrong. I don't heard anything from them about that. Simply have not met their burden. Bottom line up front in my mind is the Court of Appeals got it right, and this case should be affirmed, or even should be deemed as review having been improvidently granted. I think the main issue from the plaintiffs in their request for review was a belief that this case somehow kicks open the floodgates of litigation, and that now because of this case, this common knowledge exception is going to just say any issue now, any error, any removal of tissue. I think those are her words in the request for review. Any incorrect tissue is now medical malpractice. But that's not at all what the Court of Appeals held. The Court of Appeals held, just as Justice Wall, I think, was directly in point with your questions. This is a site issue. Dr. Louie is in the wrong part of the body, and he removes part of the wrong organ.
Bill,
Yes, Justice Wilson.
In considering common knowledge, though, I would expect any member of the jury to understand that people have two legs, and that if wrong leg is amputated, or would say, well, that was a mistake, that was negligence, that should never have happened. I don't need a doctor to explain that.
Sure.
But tell me how a common juror, let alone 12 jurors, are all going to understand not only that people have adrenal glands, but what's near an adrenal gland and how it's removed and how it might be complicated by blood and scarring, and what a doctor is to do without a doctor explaining that to them.
I think that this case is directly on point with Schwartz v. Abe, which is the case where the healthy disc was left behind and the healthy disc was removed and the diseased disc was left. We expect surgeons to have that kind of expertise. And this case is, I think, less technical than the Hyatt v. Grace case or the Bernsden v. Johnson case, both of which were cited by the Court of Appeals. I don't think this is an expansion or broadening of the common knowledge exception. I think it's just an application there. And laparoscopic surgery is very common. We all know somebody or have undergone it ourselves. And the average person is going to understand this specialized surgeon went in to remove a diseased organ and they left it behind and cut out something else. We're not saying that's medical malpractice. We're simply saying a juror understands that, and that could be medical malpractice. In this situation,
they know that without having a doctor explain that to them.
Correct. I do believe that if you say to a person, I went in for surgery and my doctor left behind a diseased organ, cut out a healthy organ or a big part of a healthy organ, any person off the street is going to go, yikes, something went wrong on that. That's the concept.
How do they know the difference between when that's negligence and when it's not negligence?
Well, I mean, I think that's where the focus will have to be at trial, obviously.
Why wouldn't you have to come forward with expert testimony to help that juror? Because we're talking about jurors' common knowledge. And I agree with you that what you just said, that you lay those basic facts out, and a juror is going to, within the juror's common knowledge, going to be able to say, this sure looks like it could be negligence. Right. But if it's not res ipsa, which is it is negligence, then that means it might be negligence, it might not be negligence. Okay. And there has to be some way for a juror to pick one or the other. That's where I'm struggling. Like, how does an ordinary juror know whether it was or wasn't?
That's a fact question, Justice Stegall.
I agree, but what evidence are they supposed to rely on to come to that conclusion, the factual conclusion?
That evidence would be presented at trial through fact witnesses. In this case, there would be 2 doctors who are already listed, not as experts, but as fact witnesses. Both Dr. Louie and Dr. Boyd are both listed as fact witnesses.
But without some testimony as to the standard of care and whether the standard of care was breached, which can only come in via an expert.
The defendant.
How would they, again, what is it in a juror's common knowledge that would help them distinguish between those two things?
Please don't take this the wrong way. I'm not making any kind of accusation, but it feels a little bit elitist to me, a little protectionist to say only a doctor can say that a doctor made a mistake. I think we can all understand at some point, just like with the legs, at some point, the doctor has screwed it up.
And I actually agree with that. Again, but this circles me back to my concern that res ipsa and the common knowledge exception are actually so close to one another as to be virtually indistinguishable.
Right. And I don't know that I would agree that res ipsa is not at play. It's not at play before this court, but the Court of Appeals said res ipsa is not at play because we believe it's the common knowledge and we're kicking it back for findings. So it's still in play. It's just not in play in front of y'all. So not.
Would you say then that, like, in under the common knowledge doctrine, the plaintiff has to present evidence of the act, you know, that deviated from the applicable standard of care and the injury sustained, and then the jury utilizes common knowledge to assess the wrongfulness and whether or not there was causation. But in res ipsa, the plaintiff only has to present, here was what the injury is. So is that the difference between the two?
So Justice Standard, just so I understand the question, like you want me to tell you my thoughts on the difference between the res ipsa and the common knowledge exception?
Right.
I think you've got it. Yeah, that's my understanding of it, certainly, and Your Honor's probably.
So res ipsa, you don't have to talk about the standard of care or anything like that. You just have to say, here's what the injury is.
Right.
And we can assume from the injury, you know, I mean, you've got all that. But with the common knowledge, you have to say, here, you know, here's what the duty was. Here's what the breach was, you know, and the jury still has to decide, but they're just using their common knowledge. They don't need an expert to say, yeah, you take out the wrong organ, you know. I mean, it's just right. Okay.
Yeah, and I think the argument, you know, to the jury is something as simple as there are a lot of cases with the nicked bladder. You know, the bladder's squishy and it moves around, and so the doctors are trying to do the surgery and they're cutting out whatever it is they're cutting, and they nick the bladder.
But the object isn't to decide whether or not a mistake was made.
Understood.
The result happened. The object is to say, you've got a reasonable doctor here, got an doctor acting unreasonably here. You decide whether going through this entire process, you understand from your common knowledge, this was reasonably done, despite the mistake, or it was unreasonably done, caused the mistake. They have to decide that with their common knowledge, don't they?
Right, but I was just saying between, that's common knowledge, right?
Correct.
But not, I was just trying to point out the difference between common knowledge and res ipsa.
Your point is taken, Justice Standards. To your point, Justice Wilson, I would say that that you are correct about that. At some point in my mind, it's a fact question. It becomes a fact question of, is this a mistake as the defendants couch it, or is it beyond a mistake to the point where it's not sinister, not criminal, but it's negligence. It's negligence on a civil tort level. And I think the evidence of
struggling with where that line is, though.
Yeah, I think the evidence.
I don't know if you fully answered that, but I just want to, I'll drop a flag there and just say that. But please, I didn't mean to interrupt you. I thought you were finished.
No,
So
you're
if
fine,
you have
Justice.
more in response to Justice Wilson, please finish.
I think to follow up with it is that Justice Louis filed a false medical report right after the pathology came back saying that you didn't take out the adrenal gland, you cut out part of the pancreas. And it was after that he filed his medical report saying that Dr. Boyd was with him the whole time. And Dr. Boyd wasn't with him the whole time. And it took kind of a lot of discovery to finally get that admission. And I think that is a Van Zandt issue. That's evidence of a cover-up. It's evidence of the criminal mind sort of thing. Again, it's not a criminal case, but I'm sorry, Justice Luker, what was your?
So my point is, or my question is, where does the common knowledge end and start, frankly? So I agree that there's some common knowledge appeal to saying, oh, you took out the wrong organ. But if the fact question is that the jury then sees essentially what that anatomy is, the size of the adrenal gland, where it sits, and they then look at that and go, well, yeah, I couldn't discern which was which. And I don't know if there's film of this laparoscopy. Sometimes there is with laparoscopy, but watching that procedure, they may be sitting there and going, I can't differentiate. And so a common person could not do this surgery. And so is that then necessary for there to be an expert who explains the surgery, the risks, the complications, the reasons it may be difficult, all of those sorts of things that at that point removes it from a common knowledge in order to be able to find the breach of the standard of care or even causation?
Maybe somewhat of an unsatisfactory answer, Justice Luker, but I'll just circle back. I don't think that we're creating new ground here. I don't think that we're expanding or broadening the exception at all. I think that this is somewhere very akin to the Abe decision, and it's less technical in my mind than the Hyatt v. Grace or the Bernston v. Johnson, both of which I think you would need a doctor to say, these technical issues were malpractice. But in my mind, we're right in the middle of what the ground the court has already plowed. It's not something new. So how do you? Sure.
I mean, a disc, to me, a disc is a disc. There's a discernible, that's very discernible.
But again, I mean, think all the nerves and everything back there. I mean, only a specialist is going to be able to do that. That's not a common. But
again, if we're talking about discernibility even, sure. And I'm not sure that's true once you're in the abdomen. That there's that same distinct, this may not be as distinct as right arm, left arm, but it's pretty distinct. But some parts of the abdomen are not necessarily that way.
I don't disagree. I don't have a lot of medical knowledge myself. And so I think there's education that has to be done, but to suggest that the average person, the average juror can't wrestle with those and can't be educated on those things to at least understand the issues, I think that's just underestimating.
Don't you have to have an expert to do that education?
No, Justice. I think that would be a fact witness could do that. And there are 2 doctors that are already on the witness list. So that can be done in lots of different ways.
The question though, wouldn't it be, would under those conditions be within the standard of care to have difficulty ascertaining which was which?
I understand your point, but I'm saying that it can be done. I think that it could be done. I've done a lot of trials and I think that could be done.
Standard of care question without an expert.
Well, I've obviously not done standard of care questions without an expert. I'm saying that I think jurors can be taught, here's the body, and then they can make the decision whether they believe that this is beyond the ordinary, or if it's something extraordinary, which we're arguing that this is extremely extraordinary. It's a one-off. It's not, as counsel stated earlier, fortunately, this doesn't happen a lot. This is a rare situation. Again, not kicking open floodgates of litigation. This is a rare situation.
I'm not concerned about that, but I am concerned about the standard of care issue in a and how we draw the line about when that kicks in. Because not worried about the floodgates, but just talking about the doctrines, it kind of seems to erase the doctrine of standard of care in medical malpractice, which I understand may not have always been true, but as medical procedures, because of the use of electronics and other things, do become more complex, there may be reasons for that to shift somewhat. Thoughts about that?
I don't think I have anything to add to my initial.
Can I follow up and
Sure.
then maybe you'll have thoughts? I don't know, maybe
Go ahead,
not.
Justice Speaker.
It just strikes me, listening to Justice Lukert's question, that in fact, the argument does threaten things like the doctrines of standard of care. And that's what makes it akin to res ipsa. I mean, that's really what's going on here. Regardless of whatever sort of legal descriptions we give to these doctrines, what's actually going on in the common knowledge exception is we're handing to jurors the ultimate question and just saying, you get to decide it. The thing speaks for itself. You amputated the wrong leg. Thing speaks for itself. It's just within your
Right.
common understanding that this should never happen. But the jurors are not going back to the jury room and saying, what's the standard of care? Was the standard of care breached? Because they have no idea. They don't have common knowledge about those things. That's not what's actually happening. Would you agree with that?
I don't know why that couldn't be something that would be provided to them. I mean, that could be something as simple as a PIC instruction almost, that here's the standard of care and here's how it would work. I don't know why we would need an expert to do that. And another question, Justice Stegall, is why are we concerned about giving the ultimate question to the jury?
I'm not sure that we should be. I'm just, again, I'm really trying to dig into the doctrines that are at play here and have a clear understanding of what we're actually saying.
In my mind, the district court did not make the fact findings that needed to be made for this court to expand upon some great legal issues. But the res ipsa loquitur, I think that's all still on the table potentially. Just because the Court of Appeals didn't reach it doesn't mean that it isn't viable in my mind.
You didn't cross petition on that issue, right?
Correct. We believe the Court of Appeals mandate just sends it back for further orders and findings.
And given the procedural posture in which this case has come to us, when we're making the determination about whether this doctrine should apply, do you believe we are limited to the summary judgment record? I mean, in other words, we've heard a lot of discussion today about, the microscopic enhancements that are required and some of the details of the surgery that may or may not have been a part of the summary judgment record. But at this stage, given the posture, are we making that determination? I guess I'm wondering, how do the uncontroverted facts interplay with the decision as to whether this doctrine applies?
Yeah, Justice Wall, that point is really well taken. And I'm not sure a lot of the uncontroverted facts are in fact uncontroverted. I think that there are several times throughout the FinDance documentation where they suggest that something's an uncontroverted fact when in fact it isn't. Dr. Boyd, for example, never testified. He wasn't deposed. So there's no uncontroverted facts from Dr. Boyd, just as one example. I think absolutely the Court of Appeals believed that it was a court of review and not a fact-finding court. And it's always been my belief that this is a court of review. It seems to me like the defendants want this court to become not only fact-finders, but maybe fact creators and certainly law creators. So,
well, the defendant attached records to the motion for summary judgment. Medical records and do those become part of what is considered? In which case, doesn't that create a question of fact from your standpoint?
I think my point is that I think that there are questions of fact, Justice Lukert. I mean,
why doesn't that defeat the summary judgment? Because I mean, you're now saying that all of these facts that the defendant has proffered that are discussed in Dr. Louie's surgical notes are lies.
I don't suggest that they all are, but I suggest that there are issues, that there are certainly certainly are issues. And on cross-examination, those things are going to come out. I don't think we know when Dr. Boyd joined the surgery. The defendants sort of suggest that he was there during the important part, but I don't think that we know that. So that again goes back to, it's not this court's job to sort those issues. It's this court's job to tell the district court to go back and sort those issues.
Without an expert to help the jury understand what he is saying here and why what he is saying that directed his judgment calls is below the standard of care.
I guess, Justice Luker, I'll just leave you with this thought, this sort of elitist protectionist sort of idea that we've kind of moved toward. Is it justice for all, or is it justice for those folks who can afford an expert to come in and say, no, this is wrong? So I feel like the common knowledge exception still opens the door justice for all, where even poor people can come before this court and say, in this extreme situation, Justice, I didn't get treated appropriately and I want redress. That's what the common knowledge exception does. And I would hate to see this court excise it.
I'm going to push back on that a little bit.
Sure.
Common knowledge exception doesn't ask someone how much money you have or what kind of resources you have. Knowledge exception is, does the common knowledge off the street who may potentially understand how to do an adrenal or a laparoscopic adrenalectomy without having some medical knowledge?
I don't think that it requires that at all, Justice Wilson. I think that you think about something as simple as having somebody come into my house and fix my garbage disposal. That person came in and fixed my garbage disposal because I couldn't make it work. So I brought in a, quote, expert to do that small chore. Certainly a juror understands if the guy fixing my garbage disposal created some negligent issue of tort. So how is it different in this extreme situation to say only a doctor can tell us a doctor made a mistake, that we have to have an expert?
Because in answer to your question, it might be common knowledge that your garbage disposal doesn't work. That it might not be common knowledge to know whether or not somebody has to have any particular expertise.
Right. So what the common knowledge exception only allows us to avoid the expert, really. That's what it does. If we have an extreme situation like here, where a healthy organ was cut out and a diseased organ was left behind, common person is going to say, whoa, there's an issue there. Now, the defendants still have the ability to come in at trial and say, here are our defenses, here are our defense theories, and here's why it wasn't negligence, here's why it was a mistake. You aren't taking anything.
Why shouldn't that be the rule in all medical negligence cases? Aside from the fact that we'd have to overturn a boatload of precedent. Why? I mean, do you think we should even have this expert?
That's beyond me, Justice Stegall. I certainly don't say that you shouldn't do that, but I think that at some point we should trust the jurors to be able to make certain decisions. I don't think there's anything wrong with that.
Justice, Chief, may I ask one more question? Okay, so in the common knowledge exception, that when you're going through the elements, you know, the standard of care, the first thing is whether there's a duty. And really the duty is don't take out the wrong organ. I mean, so that's not even really disputed.
Sure.
What's disputed is the breach. So when you're doing it, you present evidence of the act that happened that allegedly deviated from the standard of care. And there's really no disputed fact there. I mean, the act that allegedly deviated was taking out the wrong organ. But where you're going is to the breach. And then you say, look, they took, you know, here's the evidence of the injury that happened. And then it's the jury uses common knowledge to assess whether or not there was a breach, right? And so the question is, do you need and causation? So in an instance, what makes this case different from what makes this case common knowledge when you're saying, look, took out the wrong organ, and this is a breach based on your common knowledge? What makes this different that wouldn't apply to all medical malpractice cases?
Well, again, it must not be a satisfactory answer, but I'll just circle back. I think that the courts have set the goalposts on it with ABA. And so I think it's there. I mean, the definitely removing the wrong leg is, moving the wrong kidney probably is. We agree that there are two of those. You know, and at some point, I suppose that
what's not?
Right. At some point, I suppose that we're going to say that there's something that's not. And the something that's not would be the nicking. But in this case, healthy tissue was removed intentionally and diseased tissue was accidentally left behind and not touched. That's the distinction, and that's it.
Thank you.
Thank you, everyone. This was my first time in front of the Supreme Court, and I really enjoyed it.
Would you reserve 5 minutes?
Thank you for letting me resume. I think that what just happened, the discussion that was just had is part of what I have in my briefing. It's essentially an argument that a bad outcome equals negligence. And we know that is not Kansas law. There can be a bad outcome with absolutely no medical negligence. And that's what we're arguing.
But that's
well, we've had this doctrine since, you know, almost statehood, where we've recognized this exception that some cases the outcome and the care is just so apparently wrong that it's reasonable to infer without an expert negligence or a breach of the duty of care. I guess what I struggle with in this case is maybe what every other justices have been asking about is it just seems so ad hoc as to when we apply this doctrine and when we don't. Even in this case, we've got 4 judges that have looked at it. 2 think the doctrine applies, 2 think they don't. And I'm just wondering, are there factors, criteria where we can meaningfully assess when this doctrine should apply and make that application consistent and predictable for all parties that are affected by this case law? And I don't know what that would be, but I'm curious whether you have thoughts in that regard.
One factor, I think from the research that I've done is it depends on what and where the problem arose. If everything's very close together, it's hard to tell what's what. That's different than taking off the wrong hand. I mean, it can be like in the case where there was an inguinal hernia and instead he cut the spermatic cord. They're very close together. Okay, may I go on to a couple of points that are—
Oh, sure. I don't want to hold you up.
Okay, no. I want to say that about the false medical report, that issue came up very late, like maybe at the pretrial order. And I think, and it's based on the fact that Dr. Louis dictated and it was transcribed for his operative report shortly after the surgery, like 8:08. But then he signed it, electronically signed it at about 11 a.m. There's not a change. It's just, that's the way Stromantville medical records work. You dictate it and you electronically sign it. He didn't make any changes. The issue of whether Dr. Boyd was there for the whole case, he did say that in his chart, in his operative report. The fact is Dr. Boyd was there when it was time to remove the adrenal. He was not there for just removing the adhesions, but another assistant was. And where's my number 2? In the Court of Appeals decision, the majority doesn't understand why, or doesn't explain why misidentifying tissue that's close together and surrounded by blood adhesions that look like other tissue in close proximity while viewing that area through a laparoscopic scope is so obviously bad that the ordinary person would know the conduct fell below the standard of care without expert testimony.
Can I jump in there, counsel, and follow up on Justice Wall's question? Because what you just said goes directly to the point. And in my experience, sometimes when judges are trying to apply exceptions to rules and then find that the exception is incredibly difficult to apply and sort of gets applied on an ad hoc basis, that the problem is actually with the rule, not with the exception. So I guess my question is, why should plaintiffs be required to bring forth expert testimony? Why isn't it just a jury question, which the defense can put 10 experts up there to refute the plaintiff's claims? But why does the plaintiff have to do that? I mean, that's a court-made rule. It's not in statute. Doesn't it take the issue away from the jury?
But the plaintiff has the burden of proof to show that there was negligence and causation.
And so why don't we just let the plaintiff put on whatever evidence they can muster and let the jury decide?
I think let's see, Judge Bruns dealt with that. You know, he had the dissenting opinion, and he said, unlike where a physician operates on the wrong limb or leaves a foreign substance, the record establishes Dr. Louis was performing a laparoscopic adrenalectomy that was made more difficult than normal by adhesions. And the record establishes the adrenal gland and pancreas were in close proximity. Consequently, whether the intentional removal of part of the patient's pancreas by a surgeon under these circumstances is medical malpractice is not a subject within the common knowledge of a layperson. That's essentially our argument.
It really is just that juries are not competent to decide these questions.
Well, sometimes they're not competent for issues. I wouldn't be able to explain, as counsel used an example, I don't know how to fix a garbage disposal, and I couldn't say whether it was done right or wrong. The plaintiff did not produce any evidence to controvert what Dr. Louis' testimony was about what happened during the surgery, or what was in the medical record, or our expert designations. We designated Dr. Louis and Dr. Boyd are both fact witnesses, but we also designated them as experts.
But that's not why summary judgment was granted. I think, to go to Justice Stiegel's point, summary judgment was granted simply because they didn't have an expert. Summary judgment wasn't granted because the plaintiff failed to show that, as a matter of law, based on the uncontroverted facts, that there was no negligence.
But the uncontroverted facts are that there wasn't negligence. Dr. Louis testified to that, and the designation said that. Plaintiff chose not to depose him.
Part of the problem that there may be, I guess what I'll call a reverse elitism, in that the argument of the defendant that it is possible to explain during the course of one trial, but it may take a surgeon years in order to differentiate between how it is you're supposed to do something when the doctor himself is not doing what he has been instructed. That part of the problem? How to be a doctor in 3 days?
No, we teach juries a lot of things about medical evidence all the time. We focus in on what the alleged failure was, and we explain it. But that's what we do. We focus in on it and explain it. I don't think it's fair to ask a jury to speculate on whether what happened was medical negligence. And that's what Judge McCabery has said. I just don't think it works that way. And I think that the cases support that.
Questions?
Oh, I'm on 0. Thank you very much. I appreciate your attention, consideration, and questions.
Thank you. Thank you both, counsel, for your arguments. The court will take this case under advisement.